Frivolous defenses and other dangers when you're sued for debt. Brought to you by Kenneth Chabert at yourlegallegup.com. Your advantage if you're being sued by debt collectors. A lot of people tell me they've been warned against making frivolous defenses against debt collection lawsuits. As if the debt collectors have any idea whether their case is any good when they file it. Sometimes it's the debt collector or their lawyers, and sometimes it's by more well-meaning people who make the warning. Here's what you need to know about frivolous litigation. A frivolous defense is a claim that is completely unsupported by the facts or law. Any person in a lawsuit has a responsibility to investigate the claims it makes and the facts that it alleges. And if it's not possible for a reasonable person to believe the facts, or if you know them to be untrue, or if there's no reasonable likelihood that the law will allow what you want, the action is frivolous. In debt litigation, this rarely comes up. You could make a frivolous defense by arguing, for example, that although you owed the original creditor money, your debt was non-transferable. Unless you could point to a specific provision in the contract which said the debt was non-transferable. Some people like to claim that because the banks use debt to create money according to our banking system, that no money is actually lent. I believe that some courts will find this to be a frivolous claim. In any event, you generally have to stretch to come up with a frivolous defense. You have a right to deny everything and force a debt collector to prove every aspect of its case. It's a little different in the area of counterclaims. If you seek a remedy by counterclaiming on facts that do not give you a legal right and couldn't reasonably be expected to do so, then you may be making a frivolous claim. So, for example, if you made certain kinds of claims based on the Fair Debt Collection Practices Act against an original creditor instead of a debt collector, this could be a problem. Appealing a legal ruling by the trial court that was clearly right could be found frivolous. If anything you plead is found frivolous, the remedy is usually an award of some or all of the attorney fees that the other side had to pay as a result. In reality, though, frivolousness is not likely to be a problem for anyone sued by a debt collector unless you are somehow extremely hard-headed and continue to pursue things long after a more reasonable person would have let them go. For one thing, the courts are generally tolerant of pushing the envelope on legal rights. As long as there's some reasonable basis for hoping you will win, the courts should not punish you for trying. And, more practically, if you're being sued for debt, it's generally understood that you don't have much money. And this reduces both the debt collector's desire to pursue you and the court's interest in punishing you, to some extent. Although frivolousness is not much of a risk in my opinion, there are situations where care is needed. In making any sort of factual allegations, anywhere, there is always a chance that what you say could be used as an admission, admitting that some fact is true that you later try to show is not true. Or it's an assertion which you could be cross-examined on. If you are under oath, of course, this is far more important, and any untrue factual assertion could be considered perjury. In responding to requests for admissions, a different set of standards comes into play. Remember that an admission is not exactly evidence. It removes the necessity of evidence by establishing the fact as true for purposes of the lawsuit. That can be an important distinction because once a fact is admitted, further discovery about it is not necessary and could even be irrelevant. And this means that you should be extremely reluctant to make admissions, and to do so, if at all, only when the fact is very clear to you. If you deny a request for admission that the other side later proves at trial, you could conceivably be required to pay attorney's fees for the time and effort required in proving it, if it was really clear all the time. However, you won't be cross-examined on the refusal itself to make the admission. And I've never actually seen the penalty of attorney's fees imposed, but I'm sure that it can happen and sometimes does. So you want to exercise at least a little caution in denying everything willy-nilly. Still, it isn't much of a penalty considering how unlikely it is and how devastating a wrong admission could be. Protect what's yours and don't let the debt collectors rip you off. My site and materials can help. Go to yourlegallegup.com. Get my litigation manual and forums, or get the videos and defend yourself. You'll be glad that you did. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forums. If you appreciate this video, please take a second and like it, subscribe, and friend me, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors on Facebook or YouTube, as these things help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.